served on two state boards, and I know the stress and pressure and responsibility that is upon your shoulders. I want to speak about water quality and about the oath that you all took to sit in those seats. You all took the same oath, I believe, that I did, to support the Virginia and the U.S. Constitution. I think that's really important to have citizen boards, to be here to evaluate what's in the best interest of the people of Virginia. And that means taking into consideration where we are at this period of time, what will serve the Commonwealth in its best interest as far as protecting the quality of our water. And some things have happened since I spoke to you back in December that I wanted to bring to your attention that I didn't know that you were aware of. And that is that we are in the midst of an economic disruption that is creating a lot of opportunity and good protections, businesses, things that can protect our water. And that is the renewable revolution that's happening right now. Elon Musk's company, Tesla, completed a battery project in Australia that took away the need for peak plants to deal with the storage for renewables. They reduced energy by 90%. The report came out in May. And Berkshire Hathaway Energy had a report made to their shareholders that they are 50% renewable in Iowa, on track to be 100% by 2021. And I think that's important for you all to be aware of when you're making decisions in regarding water quality, whether it has to do with the pipelines or the chicken plants or whatever's happening, that you all look at the holistic picture of what is going on and look at the trajectory as far as initial plans, infrastructure that people thought might need to be needed, and if they are needed now. And we are trusting you to use your discernment and your judgment to look at where we are right now and to make the best decision on behalf of the people of Virginia to protect our water. And I want to thank you for your time. Thank you.
Thank you.
Okay, so
Name?
Heidi DiVierci. I wanted to say that I was heartened this morning by Ms. Schneider's report on the groundwater with withdrawal permitting. And in particular, hearing words such as accumulated impacts that were used, those words were used. We've been alarmed, I am with Friends of Buckingham, we've been alarmed at the fragmentation of this pipeline review process. I did mention that word, but it does connect to all other review processes, that everything is, the review process is just this divide and conquer. You have this awesome task of reviewing this small portion, large small portion of this pipeline, and then all sorts of other processes. But you're not allowed to look at the larger picture. We would really like to see risk assessments done before the whole process is given a green light. Any processes are given a green light. I went to our local health department to ask them to do risk assessments, and they pointed me to the regional health department, which pointed me to the DEQ, and the DEQ said, no, sorry, we can't do it. So we don't have a system in place that looks at the whole picture in the state of Virginia, and that is really to our great detriment. So I think you're not prepared to look at just this one piece of the puzzle. Is not fair, and in a way puts you all on the spot. You have a huge responsibility, and you're not allowed to look at the larger picture. So please consider that in your decisions. Thank you.
Thank you.
Sly, I represent Wild Virginia. I want to make the point that the discussion that asserted that the difference between the Corps of Engineers nationwide permit and the Virginia responsibility under Clean Water Act Section 401 The assertion that that is merely procedural is simply not true. The fact is that the Corps of Engineers permitting decision is not based on water quality standards. They explicitly say over and over throughout their processes that that's not their job. That's the job of the states. And we have just heard something that really disturbs me, and that is DEQ telling you that they do not intend to enforce certain parts of your water quality standards regulation. The narrative criteria apply to these projects as well as every other project. And those narrative criteria require that all uses be fully maintained, both designated and existing uses. They require that discharges that would cause turbidity and color be prohibited. Not limited, not minimized, prohibited. They require that anti-degradation be enforced. The Tier 3 waters, the Tier 2 waters, and the existing waters for Tier 1. The Corps of Engineers permit talks about minimizing sediment discharge. It talks about temporary impacts. It talks about requirements being imposed when it's practicable to do so. Our water quality standards don't include any of those provisions. Our water quality standards don't say that you can deny uses for any period of time. They say you must fully support them. They don't say you can create these kinds of discharges for a little while. They say they are prohibited. So this is a stark difference, and it must be acknowledged. And again, for DEQ to tell you that they don't intend to enforce certain parts of your water quality standards regulation is atrocious, and you should not accept that. Now, there's been another assertion that's made by staff over and over, and that is, we've got lots of experience with Nationwide 12, and it always protects us. Everything's fine. We made a Freedom of Information Act request and said, where's the proof? We saw some photographs a little while back, years later, after some of these places have been constructed, and okay, it had some vegetation, it looked fine. We asked for every record where you've gone to a place where Nationwide 12 is applied and see what happens water quality-wise. Do you have data? Do you have photographs while it's going on, immediately after it's going on? Do you have assessments as to how the conditions there meet your standards? And the answer we got was the agency has no records to reflect that. So the assertions that they know what happens under Nationwide 12 is just not true. Thank you very much.
Away, you rolling river. I learned that song as a young child from New Jersey, coming to Buckingham, Virginia, where my family has property right there on Union Hill Road. We have 52 acres, of which the 26-acre plot is in direct line with this compressor station and the pipeline. In fact, they want to utilize an easement on our property to connect the Transco line to the ACP. We're still negotiating in court right now in Roanoke, fighting that, because there are wetlands right there where they want to construct that extension. They have yet to come to our family. I accept the fact that the air quality, they took a tour of the Union Hill area. Have you folk done that yet? Oh, okay. As well as the Virginia Dominion Power. They have not been on our land because we have forbade them from being on our land. So how would they know what they're doing with the wetlands that exist? We have unmarked tombs that are on that property as well that has not been investigated. There are a pack of injustices, inequalities that have been presented to you folk that these folk just haven't done. You know, I'm willing to allow them to walk on our property, and I'll show you specifically where the wetlands are. I'll show you specifically how what you're doing with the construction trucks to get an easement of traffic, of flow, will disrupt everything that's on there. Something needs to be done. We are the Commonwealth of Virginia, so the Commonwealth of the citizens should be taken in consideration as opposed to FERC, as opposed to Dominion, as opposed to these folk. It is high time that the environmental injustices, the racism injustices that take place in the Commonwealth of Virginia stop. Union Hill is predominantly African American in that entire square area. They have exploited them over the years. Transco started it. Why do we have to have another one on top of Transco? They're already going through. Why does ACP has to come through as well? Transco even asked that question. Why do we need another pipeline? Yes. Why can't we look at renewable energies? We have a plan in place ready to start solar production in the Buckingham area to help that economically depressed county to get jobs, to get training, to get certification through the prison system of individuals that are formerly incarcerated, convicted felons. We don't need no more pipelines. They've had 3 accidents already since 2008. Have we learned from that yet? No. And they're still being monitored, still being fined, still being subjected to all types of regulations on a daily basis.
Jason Shelton.
We're going to share our 3 minutes. I'm the pipelines manager for the Sierra Club. I'm also a professional licensed engineer with over 30 years experience on the erosion sediment control. The University of Virginia hired me to be their administrator years ago. I reviewed the plans. I can tell you what's happening in the field. They put the water bars in, it takes the runoff and diverts it to the edge of the corridor where it hits the perimeter controls, builds up, accumulates as it goes downhill. And that's what we're seeing over and over and over again. I predicted this in my comments last year when I reviewed the erosion sediment control plans, and it's happening. The problem is they are not meant to be used on slopes over 20%. They just aren't effective. They lose their efficiency, and that's it, basically. No matter how many times they come in and fix these devices, they're going to continue to fail because they're not adequate. They should have used a stronger, more stringent standard. For example, like Department of Mines, Minerals, and Energy uses on coal mines.
I'm Jason Sheldon. I'm with Mountain Valley Watch. Just to follow up on Kirk's piece, the clay diversion basins that are full between rains because the clay does not drain. So all of those pieces that are set up are set to overflow on the very next one. So everything that happens, you have erosion gullies that build up on the sides, new flow patterns form, and that's where we are. Sherry Gallagher. Issues on Sherry Gallagher's property, Sherry Gallagher's basement, Sherry Gallagher's chicken coop, Sherry Gallagher's downstream. This is the Big Stony going down in from the Kimballton Branch into Big Stony. This is farm equipment that was covered up from blowouts on that access road. So whether it's the Gallaghers, whether it's the Angles, whether it's the Bohans, it doesn't matter. You're impacting every family along this route.
The Gallaghers have been flooded out 4 times so far. That's property damage on their property. Their basement was flooded. Thank you for listening very much.
Bill Limbert, Bath County, Little Valley. Our property would be impacted by over 3,000 feet of the Atlantic Coast Pipeline. It would take out over 300 trees older than our country alone on our Miracle Ridge. This is a steep, narrow ridge. There's no way that construction can occur on our property without causing a disaster for my wife and I. We live in a karst area. Every chance in the world that we're going to lose our water as a result of this. Now, I've invited DEQ to come out and see our property because I told them in the first minute they're there that they will realize the pipeline is not going to it can't be built without a disaster for us. So I'm inviting you to come out as well. We've had over 300 people come out to our property and take our big tree tour along the path of the pipeline. We'd like you to do that as well. I've spent most of my career as an environmental regulator with a specialty in looking at construction sites for runoff and pollution. And I can tell you, no question in my mind, each of these projects, MVP and ACP, will be the hardest to control that I've ever seen. I can also tell you from looking at the plans on our property in Little Valley, the worst plans I've ever seen. You need state-of-the-art controls and limited grading areas in order to control something like this. That's not happening. DEQ has given away our water. There's no question about that. I'd like to talk just briefly about the stop work order. It's touted as a great enforcement tool. It's not. It was watered down in the legislatures to apply only to the area that's in violation. From what I've seen throughout my career, when you do that, they take the construction crew and move it up the hill onto another site and let them work there, leave the site in violation, pay a minor fine. It's the cost of doing business for these big corporations. So the stop work order has hardly any significance whatsoever. Also like to talk about hydrostatic testing. The plans are to flush out the pipes, test the pipes by discharging 1,500 to 2,500 gallons per minute into upland areas. That's the equivalent of a moderate-sized stream flowing across the ground before it enters the waterway. Massive gullying will occur. All that sediment will end up in the stream as well as the pollutants from the pipes themselves. We can't waive stormwater. We can't waive the open trench limitation. It's all given away to the big corporations. When we're talking about the variances, I didn't hear one single word about water quality. It was all about how this is going to help the corporations. We need to help the people here. And it's not just Lynn and myself, there's tens of thousands of other people along the pipeline who would be injured by this. So thank you for your help and your public service.
Hardy. I'm from Rocky Mount, Virginia, Iron Ridge Road. I've been working 4 months with this stuff. I've appeared 3 times in Virginia with DEQ. Each time I came, I gave them enough pictures, enough proof to put a stop work order at that time because of violations, sediment control, water violations. Each time I came, the first time I met with one man, Mike Murphy. The second time I met with Mike Murphy and Lee Corwell. The third time I met with Jerome Brooks. On Thursday when I met with Jerome Brooks, I gave him information enough and proof enough in pictures that I don't think you people saw. If you had, you would have done something then. But it's a travesty to this state to see DEQ not stand up and not have enough backbone to do what's right, and that's to help the people. You people are here, you're all citizens elected to this board. You swore to uphold your rights and uphold the rights of the people of this state. Therefore, I'm asking you today to forget this rhetoric that was handed down by DEQ, prevaricated, misrepresented, and not truthfully told. If you think I'm lying, I'll take each one of you out and pay your expenses and take you and show you Franklin County, Roanoke County, and these spots that they showed you that they've done erosion control. And I'll show you mud washed down in driveways. I'll show you ponds that are beyond use. I'll show you streams where the fish are dead because of the mud. I'll show you roads where they have temporary access roads coming in to the main roads that are covered with mud. Why? Because there's no erosion control. You can't put riprap rock in a mud area without it draining, getting down in the mud. You can't put those green socks and expect water not to run under it. The silk fence is no good, water runs under it. So they need to come up with a barrier or something to stop the erosion. It's ruining the drinking water for all of that part of the state. And I admonish you, please step up and do something to help the citizens of this state. Virginia is one of the most beautiful states in the country.
Board, Charmaine South. I'm an attorney with the Southern Environmental Law Center. Thank you for the time to speak today. You've been told over and over again that these pipelines and the review process for these pipelines is unprecedented. And that's true. You've never been asked to certify 2 massive interstate natural gas pipelines through steep, fragile terrain and across fragile streams, rivers, and wetlands. We applaud your efforts to get it right, but we're not there yet. Construction on the Mountain Valley Pipeline has already started in Virginia. You don't need me to tell you. These folks have told you. You've seen the pictures. Mr. Whalen, you noted, we saw these pictures this afternoon. MVP has caused landslides. It's choked streams with sediment. It's caused damage to private property. We were shocked to read in DEQ's own notice of violation that on 1/2 mile stretch of stream, that stream was packed with sediment up to 11 inches. It's unacceptable. And it's not limited to the Mountain Valley Pipeline. The ACP is underway already in West Virginia. Recent notice of violation from West Virginia DEP indicates similar erosion and sediment control failures on that pipeline. If we don't do something, there's no question that the same thing will happen here in Virginia. The Calcasieu River, if allowed, the Atlantic Coast Pipeline will cross that watershed 71 times. We don't know what that will look like. You don't know. DEQ doesn't know, but we really need to. Board, I hope you can ask yourself today, when you certify these pipelines back in December 2017, is this the kind of harm that you anticipated and envisioned? The answer to that question has to be no. But you have the legal authority right now to turn things around. Under Virginia law, and I'll read you the statute, any certificate issued by the board may, after notice and opportunity for a hearing, be amended or revoked for reasons set out in the statute or for good cause. One of those reasons is that the activity for which the certificate was issued endangers the environment. These pipelines endanger the environment in Virginia. Only amendment or revocation can fix that. We ask you to do 3 things. First, hold a public hearing. As you know, everyone is paying very close attention. These folks' on-the-ground knowledge can help you understand what's happening, how to prevent it in the future. Second, exercise your statutory authority to study and investigate all the problems concerned with the quality of state waters. And third, and this is something you can do today, invoke the authority that you have to require individual 401 crossings instead of relying on Nationwide Permit 12. The state regulations allow you to do this on a case-by-case basis when concerns for water quality and the aquatic environment so indicate. Those kind of reviews are necessary and warranted for the ACP and MVP. Now is really the time to act. As you know, pipeline construction has been stayed on both of these pipelines. That's incredible. We acknowledge and we appreciate the time and energy you've put into this so far. We encourage you, don't stop now. Don't let all of that great work go to waste and amend or revoke these certifications.
My name's Ben Luckett. I'm with Appalachian Mountain Advocate. The board's been presented with extensive evidence of the impact of water quality that have already been caused by the construction of these projects. These incidents are not minor, they're not short-term, and they're not rare. In regards to the decision by the Fourth Circuit Court of Appeals, I want to note that this evidence was not before the court when it made its decision, and the court was operating under a highly deferential standard that does not apply to the board's actions on these certifications. Virginia's narrative water quality standard prohibits pollutants, specifically including sediment, in concentrations that are harmful to wildlife or human health. Evidence is showing that the promises that were made to the people of Virginia when the board previously approved these certifications, promises that the state's water quality standards would not be violated, that promise has been broken repeatedly. And a big part of that failure has to do with the strict limitations, the way that DEQ reads its enforcement authority. In a federal lawsuit brought by a landowner whose property was inundated with sediment during MVP construction, Mr. James Golden from the DEQ was presented with photo and video evidence of 5 separate incidents where erosion and control measures were overwhelmed by sediment, large quantities of sediment left the right-of-way, and streams ran red, brown, opaque with that mud. And Mr. Golden testified that he couldn't say that any of these constituted a violation. And in fact, the only way that he could find a violation is that if the company had not taken some sort of corrective action within 24 hours. That's no matter what the original impacts are. Additionally, we've heard that DEQ does not consider something a violation if it results from precipitation event that exceeds the 2-year, 24-hour storm limit. Again, no matter what the impacts are. There's no consideration there of whether those initial impacts have caused a violation of water quality standards. And I want to be clear, the levels of sediment that we are seeing in the streams are harmful to wildlife, and they could be harmful to human health. That is a violation of the narrative water quality standard. And simply because there's not a numeric limit on sediment does not mean that narrative standard, which prohibits concentrations of sediments that are harmful to wildlife, harmful to aquatic life, harmful to human health, does not mean that standard can be ignored. So it's clear that the certifications that the board has issued, as interpreted by DEQ, do not contain adequate protections for water quality to prevent harm in the first instance. So what we need to do, what the board needs to do, is initiate the necessary proceedings to revoke these certifications and then determine whether there is any set of conditions, including enforcement mechanisms, that can protect Virginia's precious water resources. Thank you.
And never said the words water quality standards. I was listening. They never said the words water quality standards, and that's the problem. You have inspectors out there inspecting sediment erosion control measures, but there's nobody out there qualified to assess the impacts to the water quality standards. And the 401 certification, you assured that the water quality standards would not be violated. And the staff just gave you a report where they neglected to even tell you that information. And you've heard now David Sly and Ben Luckett talk about the narrative water quality standard. In December of 2017, Melanie Davenport told you that there was no numeric criteria for sediment. And Mr. Hayes said, doesn't the narrative water quality standard apply? And Ms. Davenport said yes. You were here, we all heard it. I'm here primarily to talk about the Mountain Valley Pipeline, but obviously it's a bellwether for what will happen on the Dominion Pipeline. I'm here on behalf of Preserve Craig and Preserve Bent Mountain. You saw slides from the staff of a pipe up on top of Bent Mountain, a perch aquifer, a unique environment in the state of Virginia for which there is no other. And you saw that pipe sitting in water. That's the water we drink. How many people in this room drink that water where that pipe is sitting in? That many people drink that water, and there's several hundred more back at home. And that pipe has coatings on it. Ms. Chandler will give you a report of the contaminants that are going to end up in our drinking water. There is no public water supply on the top of Bent Mountain. There will never be another public water supply on top of Bent Mountain. There cannot be a public water supply on Bent Mountain. Now, this right here, August 2nd, after the stop work, after control measures were put in place, this is the North Fork of the Roanoke River. Endangered log perch habitat. 30 years of recovery in the shitter. 30 years of public resources to an endangered species that is impacted by sedimentation. Not temperature like Ms. Davenport tried to tell you in December of 2017 when we didn't get to refute the staff report. They are killed by sediment, and this happened during their spawning. North Fork of the Roanoke River was assaulted during their spawning. This is after sediment. We don't have any good pictures before they fix the sediment erosion controls. This is a crime. This is a crime. This right here is Grassy Hill Road. This was taken August 2nd. Now you've heard staff say there are two places. One is here. This morning, this person called me this morning. All of the hydroseed and the straw is in the creek this morning. All of the measures have collapsed. 10 places where sediment is entering the stream, this morning, Grassy Hill Road. It's a crime.
Good afternoon, Chairman Dunn, members of the State Water Control Board. I'm Peggy Sanner, Chesapeake Bay Foundation. Appreciate the opportunity to be here this afternoon. We've all heard a lot of discussion today on a lot of subjects sort of related to the pipeline issue, okay? Limits of authority that apply to DEQ, limits of resources that DEQ experiences, distinctions between different kinds of water quality standards, narrative versus numeric, what can be measured, what cannot be measured, the meaning of violations, what happens when we inspect, what are the various levels of inspection. All that stuff is important. It all shows to one degree or another that, in my view, members of DEQ are trying to live up to their responsibilities, and I think we should appreciate that. But I'm here today, as are probably most everyone here, to say that's really not the question. Is DEQ doing everything it can do to make sure that Virginia law, erosion sediment control standards, stormwater management rules, is that being followed? That's not the question. The question is, what is this board's responsibility under the Clean Water Act, Section 401? You've heard this before, but I think it's useful to come back to what you are obligated to do, what you are being requested to do today. And that is to determine whether, given what we know now in August, not what we knew or thought we knew would happen in December, or what we perhaps had questions about in April, what we know now, based on the evidence that has occurred in the Mountain Valley Pipeline situation, whether there is reasonable assurance in the web of controls that DEQ has worked hard to put in place, in the actions of DEQ staff who are trying to make it work, whether that's enough to provide reasonable assurance that water quality standards will be protected. Based on the evidence that we've seen and the evidence that we've heard about today, I think it cannot be said that there is reasonable assurance that water quality standards, all of them, not just the numeric standards, but also the narrative standards, specifically one that people have been alluding to today, 9 VAC 25-260-20, that sets forth general narrative standards, including a standard pertaining to turbidity and sedimentation. Both of them are deeply implicated by what we've heard about today and what we've seen. If the board, based on what we know now, finds that there is not reasonable assurance that all of these applicable water quality standards will be protected, then the board has to decide whether or not, the board has a few options to take. It can look around for, based on its own investigations, based on the help of DEQ, additional measures that will in fact do the trick, or it must revoke the 401 certification that it has provided. And I submit to you, based on what we've seen so far, revocation is the appropriate remedy under 401 the Clean Water Act. Thank you.
Chandler, I'm a landowner, homeowner on Bed Mountain. I draw that distinction. You've heard me tell my story of our property is basically a box, and we have many, many elements of water which would be important in the scenario of MVP that has upland headwaters that I've had Army Corps come to our property. Mr. Todd Miller, I asked him to arbitrate the science between my wetland scientists and what Tetra Tech, both of whom recommended don't come through this area. And I can't help but be pushed to say Mr. Miller squished in a squishy spot and said this is not really my jurisdiction. So I have a hard time with the confidence of the Army Corps overseeing some of this. But I want to bring this to a common denominator. That being on Bed Mountain, we have unusual geology, we have a perched watershed, all of our drinking water sits on top. At the spring box, which I've written to you about, 31 inches of dirt. It will require blasting. MVP has placed the center line in 4 different positions and finally settled right back at 12 feet away from that spring box. That's not the edge, that's the middle, which means it will be eradicated. That's a residential source of drinking water. My well also stands to be blasted by the corridor at Mill Creek, a big BMRC site behind us is I can't even imagine what, that diagram doesn't do it justice. But the common denominator of drinking water for all of us, Mr. Whalen, I remember you said you have a well. Think about how you woke up this morning. What do? You go to the bathroom, you brush your teeth, you take your baby aspirin, you know, run the dishwasher, the washing machine. All of those things are about to be gone for me. Pam Dodds has looked at our geology on the plateau of Bent Mountain, most assuredly says we will likely lose our water sources. You can't live without water. The pipe at Bent Mountain is just yards over the ridge from our property. That pipe is sitting in the drinking water, in the aquifer. It's taking a bath, and the coating, we have more pictures to share of the coating frittering away at welding sites. Dr. Tina Schmuz from Montgomery, I'll leave this set of documents with you, talking about the toxicities of the outside and the inside of the pipe, of the coating of the pipe, the carcinogenic possibilities in that pipe. Not possibilities, they're certain. You're putting a Superfund in an aquifer. The gentleman who showed the pipes and the cross pipes and dewatering, if they're not taking rainwater and dewatering the Parkway Crossing at 221, they're dewatering my drinking water. They're siphoning off our drinking water, they're pumping it today. That's not reasonable assurance of water quality for me. I don't want to live off of a water truck. One of the tree cutters told me he had to haul water for 3 years. Every week he had to go get water. I go to great lengths to get BPA-free, ceramic-lined things for my family. I don't want to drink water out of a truck. It's going to happen to all of us.
John Sokolow.
Dunn and members of the board, thank you very much for the opportunity to speak. My name is Jonathan Sokolow. I'm an attorney and a writer. I live in Fairfax County. I don't think it's a secret to anybody in this room what's going on here. We just heard a few minutes ago that a motion has already been drafted before the public comment period, so I don't think there's a whole lot of value being put in this comment. I think it's a damn shame, actually. We have people from around the state who travel here to tell you the story of Union Hill, which is an 85% African-American community, historic community in Buckingham County, that will be destroyed if this board doesn't do something about it. That's a damn shame. We have people who travel from Bent Mountain whose water supply is going to be destroyed unless this board does something about it, and that's a damn shame. And the same for Franklin County and Giles County and so many communities across the state. They're depending on the board to stand up for Virginia, to stand up for our water, to stand up for our air. So you should do something about that for the people in this room and the thousands who they represent. But there's even a bigger issue, and that issue is this. Will you stand up for yourselves? Will you stand up for yourselves? This board was created by statute, by the legislature, to oversee Virginia's water quality standards. You're being told by DEQ and Mr. Paylor that you don't have authority to revoke the 401. It's not true, I've read the law. You're being told that they can't do a stop work order. That's not true. I've read the law. So there's a fundamental institutional issue here as to whether you all are going to roll over and do what DEQ tells you to do, or whether you're going to preserve for future generations the authority of this board to stand up for not only yourselves, but the people of Virginia, the people of Union Hill. It's imperative that something be done, and you need to go back, revoke the 401 certifications, direct that a stream-by-stream analysis be done. And I just want to add one other thing. We've heard lots here today about how the national standard, NYP 12, is the same as Virginia water quality standards. I know somebody who doesn't agree with anything that DEQ said. I know a very important person who doesn't agree with a thing that DEQ said. His name is Dr. Ralph Northam, who said in February of 2017, when he wrote a letter to Mr. Paylor, that he thought, when he wanted our votes, that the national permit was insufficient to protect Virginia's water quality, and that instead this board and DEQ should go by Virginia's water quality standard. So I'm perfectly happy to say if it's good enough for Dr. Ralph Northam, it's good enough for me. Thank you.
I'd like to thank you for the extra few minutes that you've allowed us. I appreciate it. I sat in a tree for over a month to protest these pipelines, so it is very important for me to be here in front of you. And I'm here as a landowner and also to represent all of the landowners and people being affected by these pipelines behind me.
I'm here to ask, I live on Mid Mountain, where the pipeline is crossing the Brillo Ridge Parkway. The entire plateau of Mid Mountain is a wetland, and our groundwater that supplies our well is a perched aquifer. And at the Blue Ridge Parkway, the aquifer has been breached, and as a result, the pipe has been sitting in our drinking water for weeks. I know that's been said. I feel it bears repeating. This is not an EMS issue. It is a water quality issue, and what is not addressed by the Nationwide Permit 12. This, along with thousands of reports from citizen volunteers, show that this pipeline cannot be built without serious degradation to our water quality. That despite the best management practices that look excellent on paper, citizens have thousands of photos and hundreds of videos showing otherwise. And our own governor has admitted that there is too much sediment in the waterways as a result of this sloppy, incompetent construction. And as all of this evidence shows, that is not only is the Nationwide Permit 12 not adequate to protect Virginia's waterways, but no permit and no level of best management practices will do that. So I'm here to ask you to initiate a formal public hearing to consider revoking the 401 permit. Thank you.
Genesis Chapman asked that I substitute in for him.
Is he on the list?
Yes, this is on the list, yes.
Thank you, sir. As I read this particular provision for you, I'm humbled to bring up the rear. I'd like to point out to you, excuse me, sir?
What's your name out for the record?
My name's Roberta Bondren. I'm from Bent Mountain, Virginia. I'm here on behalf of Preserve Bent Mountain and the Power Coalition of groups, grassroots, volunteer groups from across West Virginia and Virginia. What you have before you is photographs and diagrams, documents, and basically a primer on many of the issues that have occurred across the line on MVP and ACP. Dr. Dodds has done a report, 2016 of December, on behalf of Roanoke County that's been filed in FERC and with DEQ. And again, here you have a picture of the pipe standing in water. I'd like to say, in terms of the help we get elsewhere, perhaps FERC was either misled or confused by MVP yesterday in a filing that went in at 8:36 a.m. that the section that you're looking at on the last page of this document was not buried, that it required trenching, and that the bore pit at 221 required grouting. This site was closed the day after cameras were on it on July 14th. It's completely buried over on both sides. And so I encourage you to look at my comment that was published this morning in response to that. The Army Corps of Engineers, Mr. Raylan, you were asking about the participation of the Corps, and I believe Ms. Dean, you were asking about. We saw the Army Corps with the Roanoke Pipeline Advisory Group in April 2016. We haven't seen him since. Mr. Miller promised he'd do a parcel by parcel visit, get landowners' permission to look over those places so that there would be something akin to a stream by stream or individual analysis. Not so, Mr. Dunn. That didn't happen. Even the DMRC representative remarked that the Corps wasn't there. And DEQ, again, you ask, does it have to be a violation? And I think you have from Charmaine, from David Slide, from Tammy Belinsky, and Ben Luckett, the confidence at this point, having, I think your understanding of this process has evolved to a point that you see that there are mechanisms where your question in April was essentially, does the Nationwide Permit 12 protect streams and wetlands? And I think you've seen an abundance of evidence. And please take your time and look creatively at mechanisms that allow you to resolve the concerns that you have for that. If you have unanswered questions, postpone decision on this, and please confer among yourselves and with council as to what can be done. But we feel that you've heard sufficient guidance today that you can suspend the Nationwide 12, My guess is you've explored these resolutions before you've gotten here today, and we'd ask you to do that. You can revoke the permit. There were several things listed. Again, in closing, you've heard several people raise their hands that their water is impacted. The people I'm asking you to think about, and the people who you've encountered in many of your communities, I know some of the towns come into my recognition. Not myself. I might be able to move. I might be able to relocate. I might be able to buy myself bottled plastic water. Other people cannot. I've given you in my filing on Friday, the 10th or 11th, I believe, photographs of the first people impacted by drilling on Bent Mountain, under that road. And MVP and DEQ don't even know if they've accomplished that complete package yet. They think they have to grout, but it's closed over right now. So groundwater sediment to people of lesser means. So those of lesser means and the elderly, heavily impacted. Thank you, sir.